Juvenile courts conduct private hearings but are still considered a public arena. Juvenile courts and the juvenile justice system is publicly disapproving of youth's behavior and the official response to delinquency. Due process of law is procedures designed to safeguard the rights of people who are accused of crimes. The United States was founded on many principles and ideas revolving around democracy and how all people in the states are equal under law and everyone had civil rights. Surprisingly, children of the juvenile justice system were denied many of their constitutional rights until the late 1960s and in some cases are still denied them today. History background. U.S. laws are based on British laws. The exempted children under the age of 7 that exempted children under the age of 7 from legally responsibility for delinquency because they were considered incapable of understanding right from wrong or the consequences of their actions, which is also defined as mens rea. Over the age of 7, children were considered to have this mental state of mens rea developed and were held accountable and responsible for their actions and tried as adults. Chancery courts were developed to deal with children's problems such as neglect and abuse, not so much behavioral issues, and parents were responsible to support, supervise, and care for their children. If they couldn't or refused to, the parens patriae was put into effect, meaning the king or the state would be the ultimate parent and would give him the right to care for the children. The Chancery courts set an important legal precedent that would impact the juvenile courts dramatically for centuries. Children were treated the same as adults. They were tried in the same criminal courts, detained in the same jails, sent to the same correctional facilities, and even sometimes executed. Three developments that happened to change or alter the way youth offenders were treated is one, in 1825 in New York City, the House of Refuge was created. This was to separate correctional facilities for children between the ages of 7 and 14. Second, in 1841, the city of Boston were the first to try out the program called probation. This meant that the children who qualified were able to be released under supervision of the criminal court. It is a way of treating juveniles outside of correctional institution. And lastly, in 1869, the state of Massachusetts officially established probation with supervision for juvenile law violators. These three developments changed attitudes towards childhood and helped create the idea of adolescence.
Juvenile Court. In 1899, the first statewide court for children was created due to the passing of the Juvenile Court Act in Illinois. This separated the traditional adult court dealing with family and criminal matters and allowed a focus on juveniles. Each juvenile court acts under the laws of the state in which it exists, therefore, the state determines the power and limitations the court has. Juvenile courts are usually not their own individual court. In most cases, a judge who rules on criminal or family cases will listen to juvenile cases. At that time, the court will become a juvenile court and follow such procedures. To differentiate between criminal and juvenile court, different terminology is used. The main focus and goal of the courts is not to determine guilt or innocence, but rather to investigate and figure out the best solution and treatment for the youth. In 1920, the U.S. Children's Bureau recommended the following as essential characteristics of the juvenile court: 1. Separate hearings. 2. Informal procedures. 3. Regular probation services. 4. Separate detention. 5. Special court and probation records. And 6. Provision for mental and physical examinations. This allowed for juvenile procedures to be different than criminal procedures. It allowed for more private and focused on juvenile and family. Now, in more recent times, the nature of the juvenile court has changed and taken a more formal approach similar to the criminal court environment.
Okay. Hello. I'm from Victor Shaw's class for Sociology 384, and today I'll be discussing juvenile delinquency, a sociological approach, doing chapter 13, and my certain section is called Juvenile Courts and the Media. So I started my outline by stating that programs and motion pictures often show juveniles involved in crime and interacting with the police, but they rarely provide a sight inside the juvenile court. Real life is different than seeing through a black screen, meaning that what you see on TV isn't always true. Once apprehended and juvenile status affirmed, however, juveniles are quickly separated from adult offenders and shielded from television and newspaper reporters. My next bullet point is juvenile courts are very confidential to juvenile records. They recognize the news media mission to inform and educate the public about the judicial system and how it works. They are still being facilitated to public scrutiny. Even so, juveniles get older and are involved with serious crimes. They may go through a waiver process and be adjusted as adults and remanded to adult criminal court where their cases are open to the public and the media. And that ends my section on juvenile courts and the media.
Juvenile procedures. The intake procedure of the juvenile court begins when the court is given the name of a juvenile, which is known as a referral. These referrals mainly come from the police, but could also come from parents, schools, or social agencies. In terms of percentages, 81% of referrals come from the police, 3.5% come from parents, and 2.9% come from schools. After receiving a referral, typically a probation officer is assigned to investigate the case to determine how it should be handled. In occasions of minor offenses, juveniles are released into the custody of the family. In occasions of serious offenses, juveniles are often held and detained for further investigation. Probation officers will investigate the youth's social background, interviewing teachers, neighbors, and those around the juvenile to gain more knowledge towards the situation. The probation officer can recommend that the case be dismissed early or file a petition for a hearing. During the intake procedure, the judge has the ability to declare a juvenile as an adult, moving the case to a criminal court. In 1997, the U.S. House of Representatives passed a bill that allowed states to place juveniles aged 15 or older who had committed serious felonies into an adult court. The seriousness of the offense and age are key factors that turn a juvenile court case into a criminal court case. But many argue that other factors, such as race, ethnicity, and gender, are involved that may make that decision as well. In the event that a juvenile case wants to get turned into a criminal court case, a hearing must be held and justification must be given to waive the juvenile court. The intake process takes time into account the juvenile's background and social circumstances, but the time for this procedure should not exceed 30 days.
Greetings. I am from Victor Shaw's sociology course, and I'll be doing textbook 1, chapter 13 on juvenile courts. My specific section will be adjudication. So I'll start off my outline with adjudication refers to making a judgment or ruling. This phase of the juvenile court's proceeding is corresponding to the trial phase of adult judicial proceedings. If the child is adjudicated as neglected or dependent, the court identifies the youth as INS, which means in need of supervision. The youth is then seen to court as a result of having been neglected, abused, or one array are most likely to be educated as an INS. Juveniles who have committed acts that would be a crime if committed by an adult are most likely to be adjudicated delinquent. And there is also a figure on there's also a figure shown on page 346 that displays the types of cases handled by juvenile courts. Property offenses being the highest, public order and status offenses being the second highest, crime against persons being the third highest, and last is drug law violations. However, juvenile courts persistently have refused to hold open hearings for fear of public stigmatization of the youth involved. They believe that in the end, the Supreme Court will have determined two issues. One being whether juveniles should be subject to the same constitutional requirements as adult cases. Second is the degree of access the media and public should have to juvenile hearings. And my last bullet point is ultimately the education process has become more formalized and legalistic. More parents are seeking legal advice to secure the juvenile's case. Thank
I'm part of Chapter 13, and my sections are disposition and the role of attorneys in juvenile courts. Disposition is the stage of hearing where a judge hears the juvenile's case before sentencing in a criminal court. The judge will decide what will be best for the juvenile's case. The disposition is geared more towards a treatment that will benefit the juvenile rather than a punishment. There are several alternatives a judge can choose from in handling the juvenile's case. In addition, the district attorney plays a vital role in making a recommendation to the judge, but ultimately the judge has the final call. In some instances, the judge can dismiss the case and the juvenile will be released to the parents. There is an estimate that 50% of juvenile cases are dismissed. If the judge finds the juvenile's case is due to an emotional disturbance, then the juvenile will be sent to see a psychiatrist and to receive treatment at a center. If the judge has the judge has three alternatives. If the youth is an adjudicated delinquent, the juvenile will be placed on formal probation. The juvenile will be sent to a minimal correctional institution. And lastly, if the offense committed by the juvenile is of a serious nature, then the juvenile would be sent to a maximum security correctional facility. Furthermore, the disposition phase of juvenile hearings is influenced by several variables. These variables include the seriousness of the offense, prior record, age, race, and sex of the offender. Another dispositional alternative is a blending sentence. This is where a serious or violent juvenile offender is adjudicated delinquent in a juvenile court or waived to adult court and found guilty of a felony and given both a juvenile court disposition and an adult sentence. At first, the role of the attorneys in juvenile courts was not coherent until much later. Since the Gold decision of 1967, attorneys have played a vital role and an important role in the contemporary juvenile courts.
The district attorney each state is divided into judicial district, and a public election is held in each district to elect a prosecuting attorney to represent the state in a criminal case within the district. And before the petition is filed with the court and a hearing is scheduled, the district attorney may investigate the case and exercise one of three basic options. First one, refuse refused to prosecute for the lack of evidence and released the child, defer prosecution, and place the child in informal probation. In many such cases, the district attorney may make an arrangement with the child's parents not to prosecute if they will keep the child under close supervision. And number three, expedite the filing of the petition and prosecute the child in the juvenile court for the alleged offense. And the defense attorney, the Institute of Judicial Administration and the American Bar Association suggest in their Juvenile Justice Standard Project in 1977 that there are three roles that the attorneys can fulfill in the juvenile court. First one, officer of the court. The attorney became to act to the juvenile judges in the attempting to help the judge determine what is the best for York. And guardian, the guardian roles involves a situation in which the attorney takes control on the juvenile interest in the hearings, and to be effective requires that the juveniles and the juvenile parents passively follow all advice given by the attorney. And number three, the advocate roles is the traditional roles assumed by attorneys when representing a client in adult criminal court. The attorney attempts to represent the client's best legal interests and defend the juvenile against the charge outlined on the court petition.
Hi, my name is Anna Abramova, and I'll be focusing on future of the juvenile courts and the summary portion of chapter 13. So to start off with future of the juvenile court, despite all the criticism the juvenile court has faced throughout time, the future of the system is still very unclear. No matter what political party people affiliate themselves, whether it's liberal, conservative, radical, they have all come to agree that changes need to start happening and soon. The courts are having a hard time coming to a conclusion as to how they can successfully combine the rehabilitative philosophy of parens patriae, forgive me if I said that wrong, which is when the courts are seen as ultimate parents. And on the other hand, they want to punish serious juvenile offenders. The most popular opinion on the subject was an alternative model known as the restorative justice that basically states you should still punish someone who is committing serious crimes, but at the same time still try and help them return to society as functioning members. The following main points are known as the changes that need to be made. 1. Limit its jurisdiction. 2. Operate under the provisions of due process. 3. Be administered by competent judges. 4. Have adequate court personnel. 5. Have adequate availability of alternatives for disposition. So, going to the box 13.2 towards the end of chapter 13, the controversial issue: should juvenile courts be abolished? So, frustration over the juvenile court's inability to effectively handle serious juvenile offenders has prompted many of its critics to call for its abolition. Francis McCarthy believed that the delinquency jurisdiction should be removed from the juvenile courts and be reverted to the criminal courts, where they highly valued the interest of society, and by doing so, the rights of juveniles could be protected better. Many of the advocates believed that even if the underage offenders were being charged in regular criminal courts and not in juvenile courts, that they should still be kept in separate correctional facilities. The message they wanted to get across was an attempt at guaranteeing legal due process for youthful offenders accused of crimes, and not a get tough on juvenile crime philosophy. Others advocated against it because they believed that this would just make things worse in a sense. They thought that the criminal system was already burdened with so much that they would just be adding more fuel to the fire. They thought that by throwing these underage offenders into an equally ineffective adult criminal justice system, it would lead to more problems for these young offenders. They argue that by transferring them to adult criminal courts, we would just validate the lack of confidence we placed on the present juvenile courts we had. And going on to the summary of Chapter 13. The juvenile courts were established in 1899 in Chicago. So the history and traditions could be traced back to the 15th century England. Even though it is a relatively newer institution, it has had a big impact on the lives of the individuals who have been involved with the juvenile courts. The main goal of the juvenile court was to prevent troubled youth from becoming adult criminals. They have separated youthful offenders from hardened criminals. The juvenile court is like a symbolic representation that the state has, and it's basically just showing that they are genuinely interested in the youth of their community. The media doesn't have much access to juvenile courts because they are usually close to the public. It has also received a lot of backlash along the lines of the courts are too lenient, too harsh, too broad in its scope, or too narrow in its power. And the most significant change that took place was the shift toward a more formal, legalistic approach to juvenile offenses. And because of due process and increased involvement of attorneys have come into play in the juvenile courts, it has changed the way the courts practice their almighty power when they would go through the system or go through their cases. Thank you.